The Oversight Committee will come back to order. Thank you for your patience, everybody who's in attendance. We will now hear from Representative Gina Johnson, Representative Jamie Thompson, Senator Lana Tice, as well as David Coleman with the Coleman Legal Group, and Catherine Boussard with Salt and Life Global. If you would come up. Representative Johnson, appreciate you being here. Everyone else, thank you for being here as well. Begin when you are ready.
Thank you, Mr. Chair, members of the committee. I want to make note that the State Board of Ed has exited the room. They are not here for this part of the testimony, looks like. I'm also going to yield the beginning of this testimonial time to Senator Tice as she needs to get to session.
Thank you, Representative. Thank you, members of the committee. I very much appreciate you taking the time to do a deep dive into this so-called framework. I'm going to take a slightly different approach. For the record, my degree is in biology and chemistry, and there are two types of gametes, male and female. I'm asking the Michigan Board of Education to outright reject this proposed framework. It's an activist document, not neutral education curriculum, and its effects won't be neutral either. For example, regarding SEL, the social emotional learning, the most common personality test used by psychologists to identify neuroticism is called the NEO-PIR. It lists self-consciousness as a subset of neuroticism. There's no identifiable difference between being anxious, depressed, or self-conscious. And all SEL does is tell these students to keep checking in with their feelings. We're causing them anxiety. We're causing them depression. We're not strengthening them in any way. And this document, this draft, makes it even worse, especially for our pubescent girls. I have never met a woman who thought going through puberty was a good time. I've never met a woman who thought she was perfectly comfortable with her body while going through puberty. That's what you tell the kids. It's uncomfortable, you got it, it is. And you got this, you'll get through it. And the other end's gonna be amazing. An SEL training is like group therapy combined with a struggle section and is of itself causative of trauma. Kids are releasing information in their classrooms as a part of SEL that they have no business telling their neighbor kids. They wouldn't otherwise tell, but they feel pressured to. Little Johnny admits his dad was arrested for drunk driving the night before, and now he gets to deal with all the ramifications of that. The counselors that you've put in the schools to help these kids are best friends with the teachers. The parent-child relationship is getting intervened upon, and the doctor-patient privilege, the privacy of the doctor-patient relationship is absolutely gone. And these kids are encouraged to be all the feels, to tell all their feelings, to release all the information, and in itself is causing trauma, causing anxiety for our kids. So what should we do? What would actually help them? We focus them outwardly. We tell them to figure out how to help others, to treat others the way they would like to be treated. We don't need to tribalize these kids. You treat everybody with respect. You treat everybody with kindness. You figure out how to help them. You don't ask them to identify their tribes and make it worse. I just read a book about someone who was held hostage with 3 other people for well over a year. The thing he said that helped their mental health was at night, before they laid down, they identified things to be thankful about. While they were in the tunnels, their legs chained. They were identifying things to be thankful about, and that's what stabilized their mental health. This emphasis on trauma-informed language creates iatrogenic harm. The people who are supposedly trying to fix the thing are causing the problem. Not all kids need to receive information as if they've undergone trauma. Not all of them have experienced it. And it doesn't help them to get information, to get that, here's how you commit suicide, children. No, this is not what we should be teaching them in any way, shape, or form. You should be treating the actual victims. You should be helping the kids that actually need help. But this is not something that you can scale school-wide, and it shouldn't be done. When you add this to the rest of the so-called health ed climate alarmism, deforestation is a part of health ed? Are you kidding me? Of course the kids are afraid. You told them they needed to be. Their world was going to end. This environmental health should not be a part of health ed. Activism should not be a part of health ed. Advocacy is mentioned 8 times in this document, but the statutory requirement of vision health, 3 times. Dental health, once. When you're encouraging the kids to be activists, even against their parents because of a moral worldview, you are harming the children. That's not a help. They need their families strengthened, not torn apart. No health class should be teaching activism as part of the class. Teach them health. Then we get back to teaching them reading, writing, and math. We teach them to treat others the way they want to be treated. To keep the kids from feeling unsafe, we stop lecturing them about how unsafe they are. But it's very clear, this document, and I'm going to touch a little bit for a few minutes with your grace. I'm going to touch a little bit on what you guys were talking about with the sex ed portion of it. The sex ed portion is supposed to be optional. Parents are supposed to have knowledge of it in advance. It's not supposed to be spread, and thank you guys for bringing that all out. It's not supposed to be spread through all the other classes. Again, treat everybody with respect. Treat them the way you want to be treated. But with respect to these guidelines, they don't live in a vacuum. Curriculum creators will write curriculum to match the guidelines. That's how they sell what it is they need to sell. Schools need to abide by the curriculum guidelines in order for their accreditation to remain. While they're not required to adopt these standards, there's a lot of pressure associated with it. And I'm not sure if you're aware, but Planned Parenthood is the primary provider of sexual health curriculum throughout the entire country. From 2020 to 2023, they took 80% of all sex ed grant money in the United States. Planned Parenthood is also, through its different organizations, the primary provider of gender treatment in the country, the primary provider of abortion in the country. So we're going to have Little Debbie and their donuts be the one teaching us about what it means to have food health? We're going to have an organization that has a financial incentive in causing children to become gender confused or to get pregnant, be the one teaching abstinence and health? This is sheer insanity. Sex ed should remain sex ed, and while we're at it, we ought to make sure Planned Parenthood gets out of the business of it. I want to thank you for the opportunity to speak. I have much more to say, but I am grateful. Grateful to all of you for digging down into this. Grateful for all of you caring about our children enough. I don't think I introduced myself. Lana Tice, State Senator, 22nd District, also prior chair of the Education Committee for the Michigan State Senate. And thank you again for your time.
Thank you, Senator. Thank you for cutting into your session time here to be here today.
Thank you also for the opportunity to testify this morning on this issue that goes to the heart of parental rights, local control, and the moral, credible foundation of education in our state. The resolution before you calls on the Michigan Department of Ed and the State Board of Ed to reject the proposed health education standards framework in its entirety and to produce a new version that reflects the law, respects parental rights, restores transparency and local decision-making, or leave the current framework and content as is. Our resolution reaffirms the clear intent of Section 1507 of the revised school code, which requires that sex ed be locally controlled, transparent, and optional. Parents must be notified in advance, have the opportunity to participate in local advisory boards, retain the right to excuse their children from instruction that conflicts with their family's values. There are many people in this room behind me that have already expressed they don't get to do that in their school districts. We would be better, our time would be better spent fixing that problem, enforcing the way it is, before making it worse. These safeguards are not symbolic. They are essential protections that ensure families, not government, guide the moral and educational upbringing of their children. The proposed health education standards framework disregard these boundaries, even though Dr. Parnell said they don't. It embeds lessons on gender identity, gender expression, sexual orientation into required health instruction, effectively making them mandatory topics. This removes parental choice, undermines local authority, crosses a line that the legislature has already defined in law, which was passed in 2007 with a bipartisan legislature and signed by Governor Jennifer Granholm. It's not modernization the way they want to make the changes now. It is overreach, indoctrination, politically biased, and clearly sexualizes our children and causes confusion, depression, and anxiety. At a time, and this was already mentioned by Chair DeBoyer, Michigan students are falling behind in reading, writing, math, science, etc. Our priority should be improving academic performance, not advancing ideology that is perverse and highly controversial. We should not be introducing highly controversial information and calling it education when the largest body of people, the taxpayers, the parents, the grandparents, have already spoken and made it clear they do not want this. Schools should strengthen minds, not replace the values taught at home. Parents and grandparents have expressed, families have expressed, that their faith, their freedoms are the foundation of Michigan's communities. When government agencies move beyond their authority, it is our responsibility as legislators to intervene and restore the accountability. This resolution does exactly that. It makes clear that classrooms belong to families and local communities, not to bureaucrats or political agendas. By the way, the age of legal sexual activity, sexual consent is 16. I don't understand us teaching below age 16 and encouraging sexual activity. Are we encouraging illegal activity? You can't legally get married until you're 18 in this state. Are we encouraging a failure for our children? I urge this committee to support the resolution and stand with Michigan parents in defending their right to direct the moral and educational upbringing of their children. Thank you, Mr. Chair, members of the committee, for your attention, allowing me to speak. I'm going to turn this over to Representative Jamie Thompson at this time.
Thank you, Mr. Chair, members of the committee. Representative Jamie Thompson from the 28th House District, and a mom of 3, a grandmother of 4, who is raising 3 of those grandchildren since they were 3, 5, and 7, since we lost their mother in a motorcycle accident and their father took off on them. My husband and I have been the sole guardians of those 3 babies who are now 7, 9, and 11. And I will tell you that the world is hard enough to raise children, let alone grandparents raising children, which we know in the state of Michigan there are high numbers of grandparents raising grandchildren in kinship families, that we have enough on our plate to make sure that we're protecting these kids and raising them without their mom and dad in their life and helping them face everything that's going to be pushed on them so that they are not made to be victims, so that they are made to excel and thrive and have wonderful lives and keep them innocent. We don't need our schools making it harder for us to do our job. The job that we did not automatically give birth to those children, but that we chose to be their mom and to be their dad. I want to talk a little bit about something that somebody that was presenting here, the doctor. She said that they worked with the Society for Health Education, otherwise known as SIECUS. You can write this down, SIECUS. You can go to their website, siecus.org, and you will see very clearly what they advocate for in curriculums. They believe that abstinence is failing our kids. Teaching abstinence is ineffective. They believe that teaching abstinence to children threatens the fundamental human right of sex. They believe that we should be encouraging our children safe and healthy ways to engage in sex. And in Michigan, we know that the age of consent is 16. So why would SIECUS be working with our Board of Education to teach this to third graders, 8 and 9-year-olds? Yet, the Michigan State Board of Education believes that these proposed standards, that they will include abstinence, but it's barely mentioned, twice in middle school, once in high school, and each time it's presented simply as just one option and the many options on how they can engage in sex. This is hazardous to our children. This is hazardous to Michigan. Michigan law requires that this material, when discussing sex, be age appropriate. They talked a lot about children who believed to be transgender or queer being bullied. I've been serving in office for 3 years. Every phone call that comes to my office or is emailed to my office never has been from a parent whose child was being bullied for being gay or being transgender. It was for being pretty, for being smart, for being fat, for being skinny, for having blue hair, for having short hair, for having long hair. The bullying that is going on in our schools, it's a lot of economic bullying. They're making fun of children because we have kids coming in from different districts who are from different cultures, different backgrounds, different economics. Those are the kids that are getting bullied. I know of two cheerleaders in a school downriver that both attempted suicide because their cheer team was being mean to them. Not because they were gay, not because they were queer, not because they believed that they were a different sex, because they were being mean girls. And the school did not take it serious and did not listen to parents. I can also tell you that on a local level in the city of Taylor, they were attempting to present a rogue sex education program to parents who had to find out the hard way that their board was not even acting legally. We talk about Michigan compiled law. We talk about having a state sex ed advisory board that is comprised of the majority, over 50% parents, a clergyman, a healthcare provider, or health department person. These local districts have rogue sex ed boards that are operating and approving sex education for students that do not have parental consent and do not have the majority of parents serving on that board. So I want to give a huge shout out to Moms for Liberty in Wayne County who were able to get into that board, get that board shut down because they were not acting lawfully. So now they don't even have a sex ed advisory board. So if the good doctor that spoke earlier says that we are going to keep sex ed boards and we're going to make sure that we're keeping this parental consent in place, how in the heck do they think they're going to do that if what they've proposed is so confusing and vague now that they can't even do it when they're legally supposed to? And one last thing that I will add, there has been a lot of talk about social emotional learning and just how wonderful it is for our kids. And I do agree with my colleague, Senator. Thank you for bringing that up, because I oppose the formal adoption of social emotional learning incorporated into this framework of health in our schools, our K through 12. It's promoted in schools, but it does not have sufficient transparency, it does not have parental input, and it does not have clarity about outcomes. There has been actually a lot of resources and a lot of research in this. A review by the National Education Policy Center noted that many SEL programs are not adequately defined and that they push to make SEL central to schooling, raising issues about what exactly the role of the school is versus the role of the family, meaning we do not co-parent with the government. Critics argue that SEL programs require large investments in training and resources, and when improperly implemented, they do not deliver the promised outcomes, raising the question of whether they divert time and resources from actual academics. And one last thing, the concern also includes parental rights, the rights of a parent who gave birth to a child when that child grew inside of them. Not the Michigan Board of Education, not the teacher, not anyone serving on this committee. That mother and father birthed that child. The concern also includes parental rights. Parents have raised objections that SEL curriculum may encroach on their value system, their own characters, and their belief and their discussions, areas where families believe that they should be refraining from that at school. In closing, I believe that this is a huge circumvention of the law. I urge this committee to make sure that we are planting our feet firmly on the ground and that we're going to continue these conversations. And I encourage the legislature to be looking to ways to make sure that we are addressing parental rights properly within the legislation. And I urge everyone here today to vote yes on the resolution to oppose these changed health standards. Thank you.
Just if I may, really quick, I do realize that this is an emotional issue supported by many people here, but decorum in the committee room is to refrain from outburst of either support or opposition. So appreciate that, guys. Thank you. We can continue.
Thank you, Chair DeBoer. Are you able to hear me here?
There's a Y, DeBoer. There's a DeBoer, too.
DeBoyer, sorry.
Thanks.
Well. All right. Can you hear me now? All right, Chair DeBoyer, thank you. Committee members. I appreciate the opportunity to be here today. My name is David Kallman. I'm Senior Legal Partner with Kallman Legal Group here in Lansing. I'm also Senior Litigation Attorney with Great Lakes Justice Center. I've litigated constitutional and civil rights issues for over 40 years in federal and state courts and all the way to the U.S. Supreme Court. I'm very familiar with a lot of these constitutional issues. I was very involved in educational cases here in the state. In fact, you might know the People versus DeYoung case, which freed up home education in Michigan. I was a trial attorney in that case. MCL 380.10, which is part of HR 195, I helped draft that language back in the day. So I guess this all just means I'm old, and I've been around for a while. But I appreciate the chance to be here, and I think it's always important to listen to all sides and find common ground, as Interim Superintendent Carnell said. I agree with her emphasis on the rights of parents, stressing the importance of academics, the need to follow the law. I think those are areas of common ground. However, I do have concerns with these health standards as currently drafted, and I'm going to confine my comments to two basic areas and try to be as brief as I can. First is just general legal questions, conflicts within the law versus the standards, and then liability issues. So the first one, there's many legal questions that come up here with these legal standards. First, there is no clear opt-out provision in the standards regarding health and the health standards. There's constant reference to sex education and opting out. There's no such comparable language in the health standards or the health code. The reproductive health section is also important. Everybody talks about section 1507. Look at 1506. It talks about reproductive health and also allowing for opting out. So opting out of sex education does not apply to health standards. And if it did, then which standards does it apply to? I heard for the first time here today that the department's position as gender identity is now part of sex. That's the first time I've heard that in these discussions. And frankly, I agree with her. You might remember the Rauschworld case that we were involved with. The Michigan Supreme Court ruled that the word sex, for the purposes of Elliott Larson, includes sexual orientation. And so issues like this, sexual orientation, gender identity, are now included in the word sex. So if that's true, Why are these in the health standards? They should be in the sex education standards. It's that simple. And then it begs the question, folks, what falls under the definition of sex education? That's what's not clear here, and that's what's not clearly set forth in these standards. So that is a real problem. Secondly, do these standards jeopardize federal funds? And some of these I'm just going to gloss over. I just want to bring these to your attention. We are aware of the executive order, and there's other moves in Congress right now to deal with these issues. And so is this going to, give a problem to the state in receiving federal funds into local boards? And remember, MCL 388.384 requires the proper use of federal funds. So that's overlaying all of this. Third, there's a conflict here between the local school board control that we heard about this morning and these state standards. The districts must teach health standards. It's required under the statute. We all know that. Districts may elect not to teach sex ed. They can refuse to do it totally. That's not an option for the health ed and health standards. And how do these sex advisory boards apply? I've been hearing all of this, as referenced under Section 1507. I think it's pretty clear it only applies to sex education. It doesn't apply. These boards do not have any control over health education. So that is a real conflict then within these standards in the law. What about students being required to take a health class to graduate, but not sex education? And when you blur then, well, part of it's sex ed and part of it's not, you see the conflicts that are arising there. Next, number 4, these standards are vague and overbroad. And I'm using legal terms I'm sure many of you are familiar with, but us lawyers use it all the time. If a statute or a standard or an administrative rule is vague or overbroad, it's unconstitutional, cannot be applied. And I think these standards clearly fall into that. Required topics are hardly mentioned, and this has been brought up, vision, tobacco, other things that were already brought up. They're hardly mentioned in these standards. Terms are not defined. What is a trusted adult? What does that mean? What is advocacy? What is the word sex, as I said earlier? These are all vague and overbroad standards that are going to be legal problems that us attorneys are going to be using if they're passed the way they are. I can tell you right now, we get a plaintiff or something is being challenged, these are the issues we're going to be raising. And frankly, that will prevail on the way it's set up right now. Fifth, these health standards violate parents' constitutional rights and their statutory rights. There's a whole line of cases going back to the Pierce, Meyer, and these are Supreme Court of the U.S. cases. Pierce, Meyer, Yoder, the most recent Mahmoud case. All these lines of cases affirming the rights of parents, and especially opting out in Mahmoud. MCL 380.10, as we've already talked about. And this is important language, folks. You need to understand, when that statute in Michigan was passed and it said it's the natural fundamental right of parents to raise and educate their kids, that elevated these issues then to what's called under the law strict scrutiny, which is the highest level of scrutiny a court gives to any constitutional issue, and usually means the parents win. And that's codified in our statute. That's why that Section 10 is so important. Section 1507, the right of parents to be notified, be able to review curriculum, be able to opt out. But again, that says of sex ed. That doesn't apply to health. It's not there. Section 1278 that we talked about, I look at that statute and its title is core academic curriculum. I mean, it's talking about core curriculum. And then Section 1278B, small b, talks about attitudes, beliefs, value systems, et cetera. I know you're familiar with that language. But again, that's important because it's violating parental rights. We could sit here and say we disagree, and that's fine. And I hope we can all disagree agreeably. But if I have a grandchild now in the public schools or a child, and they're being taught these sorts of things, gender identity and all of that is natural and is fine and you have to accept it. I mean, honestly, folks, if somebody has anorexia, do we encourage that? Do we affirm that because they have anorexia and think they're overweight? and then tell them to keep going? What about body dysmorphic disorder? That's a thing. These people truly believe, they feel that a part of their body isn't right, like their arm should be cut off or their leg should be cut off because that's the disorder they have. But they truly believe it. So should we affirm that and help them in amputating a perfectly healthy leg? Come on, this is silliness. These sorts of things, and this doesn't mean you treat people poorly. This doesn't mean you don't give people help. This doesn't mean that you don't, meet kids where they are and get them the help they need. Of course, all of those things. But it also doesn't mean that the state should take a position then to tell everybody else who disagrees with it based on religious or moral or other grounds to say, you got to do it and you got to agree with us, or your kid can't graduate from high school because they won't be able to take the health course. I think you can see the problem that's going to come up there. Now, the last thing here on the first part about these concerns in just general is how are local school boards supposed to navigate all of this, the conflicts between state law and the health standards. What about the opt-out issue? Is a local school board just supposed to say, well, we think they opt out, now you can opt out of health class? Well, I can see a lawsuit saying, no, you can't do that. It's a required course under state law. You see the conflict, and again, the risk of federal funds. Let me just briefly go to the second, liability exposure, because this is huge, and I'm telling you, I've litigated these cases, and frankly, a plaintiff comes to us, I'll be bringing a case like this. For example, and the most important one is First Amendment civil rights violations. I think it's crystal clear here. In 3 ways. Students don't lose their civil rights. They don't lose their constitutional rights at the schoolhouse door, the Tinker case. You're all familiar with that. So what if a child refuses to go to a class where something is being taught in the social studies or the history and they're talking about gender identity and the student says, gets up, no, I'm leaving. I don't have to listen to this. Are they going to be disciplined? Are they going to lose grades? Are they going to be kicked out of the class? Are they going to face truancy charges? You see the problems. Parents, as we've already discussed above, the various statutes and their constitutional rights, I think it's very clear. And all of this is 1983 actions in federal court. We wouldn't be going to state court, we'd be going to federal court on these things. But finally, and one I haven't heard anything about really this morning, teachers. Okay, teachers don't lose their constitutional rights in these areas either. These standards would require teachers to teach areas that directly violate their First Amendment rights and beliefs. It's going to violate their rights, free speech and everything else. The government cannot compel teachers to speak in a manner that violates their conscience. West Virginia versus Barnett, and we can go on and on. I'm just bringing this to your attention that there are many legal issues and problems with what I read in these standards. I had a teacher talk to me just yesterday at my church, a public school teacher, and he came to me and said, do you know about this? If they tell me I have to teach this stuff, I'm not teaching it, I'm going to get fired. You know? What do you do about those teachers? Secondly, the failure to follow federal law. Again, I won't belabor the point, and federal funding that comes from that. Third, schools failing to notify parents of these gender issues. Look at the Rockford lawsuit that's going on right now. What about opting out provisions? All these things. Parents have the right to notice, to review, and to opt out. It's not just opt out. How are they going to get this notice or review of anything under the health standards? It's not there. Finally, health standards require teaching on topics that can trigger psychological harm, as Senator Tice was talking about. There's no counselor there. There's no psychologist there in the classroom. Look at MCL 380.1506, which includes psychological functions and how that plays into this. Again, parents have to have the right to opt their children out of these types of classes. So the bottom line here from my perspective is this. These health standards undermine the rights of parents, teachers, and students in teaching values in the areas of sex and reproductive health to their kids as permitted under state law. Secondly, I see this as a clear attempt to circumvent and sidestep the notice, review, and opt-out requirements for sex education by throwing it into health education, and then across the board, who knows what other classes they're going to do it. It's a clear attempt to circumvent that law. And finally, it veers away from schools teaching academics and teaching, as opposed to teaching their social justice issues. And I just think this is something that we as a state should not be doing. These health standards should not be adopted as drafted, and I urge you to support HR 195. Thank you for the time. I'm happy to answer a question if I've raised anything that anybody has a question on.
Good morning, Chairman and members of the committee. My name is Catherine Bessard. It's an honor to speak with you this morning. I do serve as the Executive Director of Salt and Lake Global. I also sit on my local public school board, and I've worked in K-12 education for the vast majority of my career as an instructor and administrator. And I bring that lens of experience today as I speak in my personal testimony. I just want to start talking at the very beginning about the statutes and what they require. You know, as a member of my local school board on the policy committee, we look at the law, we look at the recommendations from the department or the standards, whatever they are, and we try to follow those and adopt our policies and curriculum based on that. And so it's important to understand what the statutes actually say. And I really believe that Dr. Carnell did a disservice to this body when she spoke earlier because she misrepresented the facts. MCL 380-12.78, which she said authorizes the department to create standards for sex ed, does no such thing. The word sex, reproductive health, or HIV, to Rep. Merriman's question when he pressed her on that, none of those words even appear in the statute. How can it authorize them to teach something that isn't even a part of the statute? Quite frankly, that was misinformation. Similarly, with MCL 380.1169, she spoke about how that statute also authorized the department to teach these standards, but it really focuses the department's authority very narrowly to train the trainers of teachers for HIV information, and second, to give medically accurate information to schools so the teachers can use it. But that same law also says that any training on HIV has to follow the process set out in our sex ed law that has the sex ed advisory board working with the local school board to develop the curriculum. It is not a centralized state standard of what is taught on those subjects. That was not accurate information. And finally, with MCL 380.1507, our sex ed law, she's made it very emphatic that nothing is changing here. Well, it's really hard to say that nothing is changing when sex ed and health education are two separate classes, two separate courses, and they may be taught together at the same time, but that's really at the scheduling convenience of the local district as to whether or not they even teach sex ed and where they place it in the school's calendar. To say that nothing changes here is simply not true. What they've done with these health standards is really unprecedented. If you look back at old health standards, there was, teaching about what the law requires, about nutrition and hygiene and first aid and things like that, disease prevention and drugs, don't do drugs. That was health education. Then we had sex education tacked on at the 2007 standards, which, by the way, were a bipartisan effort that was signed under the Granholm administration. This was not some radical polarized issue at all. It was a very bipartisan effort. Those standards set aside sex ed as Strand 7. It made it very optional whether or not schools were even required to teach it. It reminded local districts of the law very clearly that if you should teach this, the first thing you have to do is notify parents. You have to allow for curriculum review. You have to allow them the right to opt out without penalizing students or grades or anything like that. And it said these are just truly some suggestions, but the health standards were the health standards. And it's important to understand, that brings me to my second point. Well, I guess I will just say, it brings me to my second point, that there's a big difference between standards and guidelines. And today we were almost, gaslit into this idea that somehow these standards being proposed are really just a suggestion from the State Department of Education on how to teach health education. A local board like mine really doesn't need to take them seriously. We can teach whatever we want. We can pick and choose what's in the standards. That was the suggestion and impression that was very clearly, emphatically, and repeatedly painted by Dr. Carnell. However, that is not consistent with the law. And when I look at the law, again, just a school board member doing my best to follow this, this would be what I would read in MCL 380.1278. The very first line says, in addition to the requirements for accreditation under section 1280 specified in this section, if a board of a school district wants all the schools of their district to be accredited under section 1280, the board shall provide all pupils attending public school in the district a core academic curriculum in compliance with subsection 3 in each of the curricular areas specified in the state board recommended model core academic curriculum standards developed under subsection 2. Health class comes up as you continue reading the statute. By the way, again, sex ed does not. Health class comes up. In other words, if my district wants to be accredited, we must teach at a minimum the standards promulgated by the Michigan Department of Education. If we fail to do so, we can lose our accreditation. So personally, I don't view that as a suggestion. I think that every student in my district is entitled to actually do the work, graduate, and have the state of Michigan recognize their diploma. I don't think we should be cheating children out of that. It is not a mere suggestion. This is not a flexible thing. And that also brings me then to think about the content here. What's embedded in these standards is really unprecedented. We've never seen climate and environmental activism or this emphasis on not trusting parents or this emphasis on sex and social issues put into health curriculum. Health curriculum needs to follow the law. And I also want to mention with parental rights here that the department has suggested that nothing's changing. Again, going back to that 1507 statute. Yes, the law is still in place. But how is a local district like mine supposed to actually enforce that? When sex and gender, just those two words, not to mention reproductive health and other things, when just those two words are listed 111 times in these health standards, if we teach health class in accordance with these standards, with this all mixed in, not just in sex standards, but in decision making and relationships, all these other areas of the standards, if we have to notify parents 111 times, every parent in the district, every time this comes up in a health class, I don't know what your districts look like where you live, but my district is very small. We don't have that big of a staff. I'm really concerned about that notice being effective. And if you notify parents, I've asked the department, what does that look like? If you notify parents just once at the beginning of the year, hey, we're going to teach this, parents don't know when it's appropriate to opt their child out. If you notify parents every single time, those notices start to kind of become something parents are desensitized to, and it's really hard to keep track of. And actually, in the Mahmood case, the Supreme Court actually spoke to that and said that it can be a civil rights violation if we don't make it clear that these are the times when there should be notice and these are the times when it's not really relevant. If we don't clearly notify parents and if we embed this offensive material throughout the entire curriculum, making it harder for parents to know when to opt out, that in and of itself can actually become a civil rights problem. And then more parents will be visiting Mr. Coleman. And as what Dr. Carnell said, when Representative Green pressed, what are parents to do when these standards are violated? It's a problem right now. There are parents sitting behind me who have been denied the right to review the sex ed curriculum in their district, Grand Ledge Public Schools. There are parents in this room who have had their children taught things that they have expressly opted them out. The damage is done. Their child has been exposed to something against their values. The remedy for a parent becomes an attorney. That's very expensive. And it's not just expensive for the parent, it's expensive for districts like mine that are already cash-strapped, trying to teach kids how to read and write. All of these things that we're talking about today, when the department clearly goes beyond the scope of the law, it takes the focus away from academics. It takes the focus away from children learning to read and write and do math and all the things that we want our children to learn so they can be successful in life. It's important that we follow the laws. It's important that parents have the right to opt out. And as I conclude, I want to share the story of a female student in my district. You may know that the Michigan Dashboard on Adolescent Sexual Health reports that we do have a problem in this state. While our good sex ed laws are doing many wonderful things, one problem that we haven't fixed yet is that 10% of Michigan students report being raped. Among female students, that number is closer to 20%. And I will never forget the day as a school board member when I received a call from a mandatory reporter, and on the line with that mandatory reporter was a mother of a student who, through sobs and tears, told me that her daughter had been raped by a boy at her school. And although the daughter was receiving counseling and all the help that her parents could possibly offer to her until certain legal procedures happened, she still had to attend class every day with that boy, see him every day, in a very small district. Imagine having to sit through a health class under these standards where topics like sex and dating violence and all these other things are embedded, where your parent hasn't necessarily received notice because there is no notice for health class. And all of a sudden you walk in blind to health class, you're hit with this thing that triggers the most traumatic nightmare that you've ever lived through. And you're stuck, numb, remembering that. And then you're supposed to walk out when the bell rings and somehow you're supposed to learn algebra or somehow you're supposed to focus on English lit. That emotional trauma is re-triggered, and as Attorney Coleman said, there's really not psychological help available. And by denying notice, by denying transparency, we're shutting parents out of that critical conversation who would love to be there to help children, who would love to be there to look out for their child's best interest, and we're denying them that opportunity. Sex education and health education are separate in our laws for a reason. Parental involvement exists for a reason. Opt-outs, safeguards, local control, all of these things exist for a reason, and the laws that we have on the books exist for a reason. They deserve to be followed with the utmost care, and that's why I encourage you to support Representative Johnson's resolution and do everything that you can to encourage the Michigan Department of Education and State Board of Education to reject these standards and redraft them so that they clearly, carefully follow the laws and respect the rights of Michigan families. Thank you.
Thank you. Appreciate everyone's testimony. I know Senator Tice does have to get going. Session's beginning. I do have a question for you specifically, and I don't know if any members have a specific question for Senator Tice, but, just talk about, it got touched on briefly by David, but tell us about the impact on teachers that you've recognized or you've understood on how this proposed standards has impacted some teachers.
Thank you for asking that, because it's extremely important. I've got some family members who have recently retired, as soon as they could get there, out of the education system because of the conflict nature that's going on between the parents and the teachers and their administration. And I'll just remind you that in this country, there are 3 major faith traditions that are oppositional to what this teaches. So it goes well beyond my personal faith. It's pretty much around the country. But when you have a teacher who's required to teach the curriculum in front of them, and it's violative of their deeply held religious beliefs, they have a right to sue if they're forced to do that. The parents, understandably, have a right to push back against the curriculum, and it's the teacher that lands on. And so we have a lot of good teachers who are walking away because there are parents who are very angry about what is indoctrinating their children. They're trying to stop it, and they're just aiming at anybody that's imparting this on their kids, understandably. We've got a whole group of people that started out because education was teaching their kids things they shouldn't be teaching them. And I absolutely relate to everything they're doing. And if what we want is to have more teachers in our schools, we need to quit putting them in a position where they're in conflict with the parents. They should be partnered with them. And you can't help them when you create guidelines like this. Help the teachers, help the parents, support this resolution, and MDE reject these guidelines and start again.
If you don't mind, I think we do have one question for you, Senator, additional. Representative Miller?
Yes, thank you, Senator. When this issue was first brought to you, did you make a recommendation that this should be a bill? Since this resolution carries no legal capacity, has no legal force, what was the intended outcome here beyond opinions and statements? And why not introduce a bill that actually addresses the concerns raised here? And if the resolution doesn't change policy, what is the purpose and how, and with a purpose, and how does passing a resolution today help improve student health? Education, plain and simple. And to the point that was made on suicides, how often or more likely is an LGBTQ student more likely to attempt suicide than their peers when they feel supported and affirmed at school? Does that risk drop?
Have you completed your questioning? Okay. So first off, we're not asking to create new law. We're asking the Department of Education to actually abide by the law that's in front of them, and they're not. They've gone way out of their lane. So what the resolution does is speak to legislative intent and remind them of what the law already says. They don't have the authority to do this. It's not within the existing law that they do this. Not only is it oppositional to existing law, parents can take them to court because it's violating federally First Amendment rights. It's violating teachers' First Amendment rights. Now, with respect to the suicide, if you look at the actual data, what's happening is kids who have comorbidities, like borderline personality disorder, if you measure all of the comorbidities and you put that up against the general population, they are aligned. Most of the kids they're identifying in the LGBTQ area have comorbidities associated with them, over 30% autistic, actually. So if you align them with the general public, what you find is those comorbidities correlate. And then what happens, and this is my experience with my detransitioning friends, is they end up with all kinds of guilt and discomfort and depression over having permanently changed their bodies in ways that they cannot correct, and they become more, not less suicidal. So I thank you for asking that question.
So to that point, do you have data in any peer-reviewed studies done either with national associations that show those conclusions that you can share with us?
The CAS review.
Thank you.
Thank you.
Thank you, Representative. Thank you, Senator, for taking the time to be here. I'd like to move quickly as we are coming up against a hard stop here soon. Representative Green. You sure? Okay. Representative Wagala.
Not going to pontificate. I just need to set up the question because it's important. So there's been a lot of conversation about how this can, conversations about gender identity and sexual orientation can make their way into other classrooms. And I was a U.S. history teacher, and I guess what I'm really curious about, are we arguing that the mere acknowledgement of gender identity or sexual orientation and those individuals' contributions to history, such as in World War II, thousands of gay individuals served in the Army, is that, are you saying that shouldn't happen in those cases? Because I would argue that is an appropriate part of discussion.
I'm happy to respond to that. Of course not. I mean, we're all Americans. We've all participated. We've all played a part in getting here today. That's not what we're talking about here. And that's part of the problem, is how do you differentiate legitimate historical, social, other things that are totally appropriate to be taught and talked about versus sex education or telling students issues on gender and things like that the parents in sex ed that should be more for sex education. That's the problem, is how do you split those out? It's a real problem. And these standards muddy it all together. That's the problem.
These standards even go to the point of teaching attraction and teaching how to engage in various behaviors. That's different than just teaching about Americans living their lives.
Of course.
Thank you.
Great question.
Representative Merriman.
Thank you, Chair DeBoer. Catherine, could you, I don't see in the law passed in 2007 sort of the overlap that I'm seeing here being tried, and the doctor, state superintendent, was suggesting that it was taught in the 2007 law signed by Governor Granholm. Is that your understanding that?
That's a great question, and no, this is really totally different. We've never seen this emphasis on sex in health education ever. And we've also never seen it interwoven and intermingled throughout the entire curriculum. In the past, they've always had, age standards and that for health education. And if anything, that most recent 2007 standard, it kind of had like an appendix called Strand 7, where sex ed, it was very clear this is totally a local control issue. If you teach it, here's the law, here's the parental protection, student protections, and it was set aside kind of like as a bonus section, an appendix. It was not interwoven into the core health standards so that it was very clear to districts, this is what you need to teach, totally optional. And these standards completely lack that clarity.
We do have time for one more question. Representative Pohutsky.
Thank you, Mr. Chair. Going back a little bit to the point about not hearing from the families of queer or trans kids about possible bullying, why would you expect a parent of a queer or trans kid to reach out to someone who is actively scapegoating them to distract from the fact that 1.4 million Michiganders are about to lose their food assistance?
It would be you that would ask such a stupid question at this hearing.
Do you have an intelligent answer?
Hey, we're gonna stay on topic here, please, both. Thank you.
I'd be happy to respond to that just briefly.
In the interest of
It
time.
wasn't for you.
Please.
Well, all right.
Please. As we are well past our time here, first I'm going to apologize. There's a number of individuals that put in cards to speak. Sheila Kuhn supports the bill, put in a card wishing to speak. I apologize to you that we will not be able to get you up. David, obviously you're here. Eileen McNeil supports the bill, wish to speak. I apologize to you. Catherine Bouchard supports the bill. Apologize to you. Kristen Lee supports the bill. I apologize to you. Lisa West supports the bill. I apologize to you. Sandra Tannehill opposes the standards. I apologize to you. Brittany Hausman opposes the bill. Wish to speak. I apologize to you. Additionally, we had 170 either electronically or personally submitted. Excuse me? The resolution. Standards, I guess you could imply, but the resolution, they support the resolution or oppose the resolution. 170 turned in that support the resolution that did not wish to speak. We're going to notice them for the record. Is that the end of it, clerk? That is the end of the wishing to speak. I'm sorry, and also wishing to just make their position known. Representative Green moves to report House Resolution 195 with recommendation. Will the clerk call the roll?
On the motion to report, Chair DeBoyer?
Yes.
Representatives Bierlein?
Yes.
Meerman?
Yes.
Paquette? Yes. Cara? Yes. Bruck? Yay. Green? Yes. Regas? Yes. Shriver? Yay. Wolford? Yay. Miller?
No.
Pohutsky?
No.
Conlon?
No.
McDonald? No. Menser?
No.
Cerniglu?
No.
Wagella? No. Mr. Chair, you have 10 yeas, 7 nays, 0 pass. H.R. 195 is reported with recommendation.
Thank you, Mr. Clerk. Seeing no absent, there being no further business before the committee, the Oversight Committee will stand adjourned.